Hi everyone, this is me Syed Shujathullah. So today we are discussing the 11th to 20th MCQs along with the detailed explanation I will give. So those who are watching me for the very first time, please watch last 3 to 4 videos and join my Telegram group to be a part of my free guidance and mentoring program. Okay, for the UPSC aspirants only. And another important stuff that I have to tell you is please be safe, don't go out, whatever the energies you are having, so put it on the UPSC and try to crack it. Okay, there is nothing more than your career in your life. Remember this point. When your career is settled, then only you will be the most happiest person. If you're not settled in your career, then always a kind of distress life it will be. So whatever you do, whatever the occupation you choose, please do with dedication. Do with dedication. This is not the end. UPSC is not the end. But the thing is, you have to be dedicated to what you are doing. What you are doing. Okay. So let us go ahead. I'll become again small. This is a very regular process I do. Fine. 11th question, right? So a little bit of my advertisement, but I'll not show much. Don't worry. I'll just slide it on. Those who are watching me for the very first time, so for them, this is the advertisement. So you can just pause it and you can see what courses I will offer them into Zoom with minimum fees. That is very common. Okay. Now I'll just directly go to the MCQs. Don't worry. So you might be seeing something new in on my slides, right? So you have seen a picture of mine at the left side on and off in the slides. Why? Because one of the students, she told me that my content is being copied by somebody else, it seems. So she has showed me some screenshots. So and she has given me this idea that, sir, you please do this so that nobody can take anything from you like that. So that is why I have put. She asked me to put on every side, but I did not do it. So I have done only in on and off. It should not be very boring to you. That's why. Fine. So 11th question. Consider the following statements of independence of Supreme Court judges. Supreme Court judges. Whether it is Supreme Court or whether it is High Court, both are same. Remember this point. But as we are discussing only Supreme Court, so I am restricting my information with regard to Supreme Court judges also. Only when we are discussing High Court, it will be a continuous comparison I will be doing with these slides and that slides, with these slides and that slides. With that, what happens? A proper overview of Supreme Court, like total judiciary, you will be thorough. Total judiciary, you will be thorough. Comparisons, I will give. You know that I give you the best comparisons. Okay, fine. So independence is nothing but under no influence. Under no influence, no coercion. We also call it law as no coercion. There is no influence of any of the other organs, any of the other organs with regard to their functioning of Supreme Court, with regard to their condition of Supreme Court, with regard to their service, with regard to their tenure, so on and so forth. So whatever they do, okay, in the Supreme Court, whatever they do, how whatever the rules they make, etc., and how they are appointed, and after appointment, what is the security of their tenure, etc., all that is not under any influence. All that is not under any influence, either from the executive, nothing but PM and Council of Ministers, along with President, so and so forth. Not even from we are having here, of course, executive is not under the even like we don't have like assemblies also cannot do anything with regard to High Court judges. With regard to High Court judges, so independence is nothing but the freedom to carry out its own affair. Freedom to carry out its own affair. Supreme Court and the judges also. So let us see one by one what it is. They are appointed without any political intervention by the president. This is a very right statement that they are appointed by the president. Okay, this is fine. So it is written here without any political intervention. This is also very right. This is also very right. Remember this point. In our last video, we have discussed that NJAC will be a commission. Okay, National Judicial Appointment Commission. This commission has got a composition. This composition consists of both judicial members and political persons and political executives. And this composition, this group of members together, they are called as collegium. And this system of collegium, okay, appoints what? Supreme Court and High Court judges. Supreme Court and High Court judges. Remember this point. So, but normal, whatever the current procedure we are following, there is no political executive or political interference. There is no political interference. All the appointments, all the recommendations of judges of High Court or Supreme Court, High Court or Supreme Court will be recommendations will be given by what? Only on judiciary. Of course, the appointing authority is president. Okay, so forget about president, that is not our concern. Here our concern is, okay, the judges of Supreme Court and High Court are appointed without any political intervention. That is also right. The present system does not allow any political party to be a part of appointing of Supreme Court and High Court judges. Fine. Judges of Supreme Court, though appointed by the President, cannot be removed on his pleasure. It is also very, very right. It is also very, very right. If you take the case of Attorney General, Attorney General generally he is appointed by the President by the aid and advice of PM and Council of Ministers. Okay, so whatever the term he is having, that term could be like 5 years or 6 years or 3 years, 2 years. He will be not given a fixed term. Okay, so president appoints him, and whenever the president wants, he can remove. So till president desires him to be a part of that office, attorney general office, he can be there. Okay, so during his pleasure, if he is happy, okay, you be there, okay, he will be there. But when he is not happy, then he can remove easily. He can remove easily. Okay, there is no due process. Due process is followed. A process of removal is not followed. In case of what? Attorney General. In case of what? Attorney General, many dignitaries, constitutional officers are there, where you will see the appointment by President will be there, and removal by President will be there on his pleasure. On his pleasure means till President desires. Till president decides. But you know that in our last video we have seen that the judges of Supreme Court and High Court cannot be removed just like that by the president. There is an inquiry, there is a parliamentary motion will be there, and that motion has to be supported by so and so members, and voting will be done by so and so majority. So a proper process is followed. A process is due. Due process means what? A process is due. That process have to be followed, then only the outcome will come. Okay, if you bypass this process which is due, then it is not possible. Then it is not possible. You cannot remove it. You cannot remove it. Okay, that's why those judges of Supreme Court are appointed by the president, they cannot be removed on his pleasure. This is also right. Then third one, salaries, allowances, leave, though fixed by the president, cannot be varied to their disadvantage during their judges' terms office. During judges' terms in the office, that is also right. But here, salaries, allowances, leaves are not fixed by president. This is a wrong statement. This is right, this is right, this is wrong. Salaries, allowances, leave are fixed by what? Parliament. Once Parliament has fixed that he will get 100 days of leaves, a judge of Supreme Court or High Court may get 100 days of leaves in a year. Okay? A judge of High Court, Supreme Court may get rent free. Okay, he can reside in the government quarters. That is also given to him. And judges of Supreme Court and High Court will get like 80,000 or 90,000 salary. That is also fine. That is also fine. And in financial emergency only, their salary could be decreased. That is also fine. Okay, and judges, they are not answerable to the parliament. That is also written. That is also okay. If suppose a parliamentary law is already made like this, okay, with regard to Supreme Court and High Court judges, already these are the some features. I am giving you some features which are just like that, which are very general. I have given you. Okay, it is not exactly, because we have to go through the Judges Inquiry Act to read what conditions, how many days of leave are there. I'm just saying you that suppose these are all okay. These are all the provisions made by the Parliament with regard to Supreme Court and High Court judges. These are all given to them. These are all given to them. Okay, so these all changes are made in the year 2020. And in 2020, 3 judges are appointed. 3 judges are appointed by the president. And 2021, these 100 days became 50. Okay, rent free become paid one. means judges of Supreme Court and High Court should give paid one. Okay, 80,000 becomes 70,000. These changes were done in 2021. Okay, can these changes will be applicable to the judges? No, no, no. Okay, once he was appointed, what kind of allowances, privileges, conditions were given to him at that time, that will continue till he retired from that office. Till he retired from this office. By that time, how many changes you made, that will not be applicable. That will not be applicable. I guess you got this point. So salaries, allowances, leave, they are actually fixed by parliament. Okay, and cannot be varied. Varied means they cannot be changed. Once fixed, they cannot be changed to their disadvantage. This is one more important point. They can increase it, everyone will be happy. Okay, they can increase 80,000 becomes 12 lakh more, that will be applicable. Okay, but anything to their disadvantage should not be a part of that particular provision. Okay, otherwise that is not be applicable. That will be applicable to the future recruits. That will be applicable to the future recruits. So any excess is bale, it's good fun. Okay, but any lower, that is not going to be applied to the already appointed judges. Remember this one. Okay. So that is fine. That is also I have told you. One is right, second is right, third one is absolutely wrong because of this one. Because of this one. No discussion on conduct of judge by the parliament until on motion of removal. That is also very true. So that's why you will never hear in the parliament with regard to the judges of Supreme Court and High Court, they have done like this, they have given this judgment, okay, they are wrong, okay, they should not behave this way, etc. You cannot say that. You cannot say that. There won't be any discussion of them in the parliament. That's why you will not see about them at all in the parliamentary proceedings. In the parliamentary proceeding, they are free. They are free from all these debates, etc. Okay, until a motion of removal of judge. You know that if a motion is there, then they will talk about the charges about that particular Supreme Court or High Court judges. But usually, there won't be any discussion. Okay, on their conduct. Fine. Judges of Supreme Court cannot plead any other court or any other authority after retirement. That is also very, very right. Why? Because in order to ensure that justice has been delivered impartially, unbiasedly, and there should not be any future privileges that a judge may get in future like that, then for that purpose, to avoid that purpose, so these provisions were added. That's why now what happened, our Bobde, okay, Bobde sir was there, honorable former Chief Justice of our country, Bobde. Okay, he retired, but he was appointed as a Rajya Sabha member. Okay, but he cannot plead. Okay, he cannot be again pleading in any of the high courts, any of the Supreme Court, or any other authority. Like National Highway Authority of India, he cannot be attorney to them. NMDC, legal advisor, he cannot be like that. He cannot represent even the state. He cannot represent any statutory authority. He cannot plead in any court. He cannot represent any private party. मेरा भी केस नहीं लड़ सकते. He cannot plead in any court. First of all, आप जाइए मत. You cannot go that. Okay, or any other authority after retirement. Okay, but you can understand that when Bobde was appointed, I am exactly don't know that it's Bobde or not, but I remember that it's Bobde only. So when Justice Bobde was appointed as a Rajya Sabha member, this is possible because being a Rajya Sabha member is not pleading, no, and Constitution has debarred only from pleading or practicing law in the courts, but not to be a member of Rajya Sabha. It's not there anywhere. That's why he was given, because I think he has given the Ram Mandir judgment, so he was got a privilege in that way. People, that articles may say, the people may say, that's what I have heard. So that is, forget about it. Okay, so in order to, so there can be like, if I am very good towards the Chief Justice of India. Okay, Chief Justice of India, and I'm very good with him. Okay, I'm a Supreme Court judge, I'm very good with him. Okay, so I have I got retired. And after retirement also, if I am pleading in a court, the Chief Justice of India will be inclined towards me or not? Yes, because I am very good friend of Chief Justice of India. Whatever he told to me, I have done all the things according to his desire, will, fancies, etc. and so on and so forth. After my retirement, I am representing, let's suppose, Tata. I am representing, let's suppose, somebody else. Okay, then I'll go to the same Chief Justice of India. Then he will be inclined towards me or not? Yes. So here justice will become what? Partial. Okay, justice will become what? Bias. To avoid this, this particular provision was added by the constitutional experts. Okay. Okay, everything has to be discussed in a very proper manner, so you should have patience to listen everything. Okay, so हमारा हो गया. Third one is absolutely wrong. 1 2 4 5 1 2 4 5. ठीक है, क्रॉस चेक कर लेंगे अपन. This we don't need to cross check because I have already told you. Judges of Supreme Court cannot be appointed. This also you know, cannot be removed by the president during his pleasure. You also know about it. Let us just read it. Okay, the judges of Supreme Court is independent. Though they are appointed by the president, though the appointing authority is president, and see first one also, the appointment of Supreme Court judge has been lifted from the pure politics, right or wrong? Pure politics means political representation should not be there in the appointment of judges. So this is also right. No political interference. Fine. That is also fine. Okay. Then, though the appointing authority is president, a judge of Supreme Court shall not be removed by the president on his pleasure, except a joint address by the both the houses of the parliament. That we know. So that's why second one is also right. Okay, because he cannot remove the judges on his will and decides on his pleasure. Okay, their proper due process have to be followed. Then let us see again. Then allowances, leave and pension which are determined by parliament. What we have written here? We have written here president. They are not determined by president. Determined is nothing but fixed only. They are determined by parliament. That's why that is wrong. That's why that is wrong. And I have already told you that shall not be varied to their disadvantage. Should not their whatever the privileges allowances given should not decrease. It can increase. That is also fine. Okay. Then no discussion on conduct of judge by the parliament until on the motion of removal. Okay. The constitution has forbidden the discussion of conduct of a judge of Supreme Court or a High Court in the parliament except upon a motion. Except upon a motion. That the state services examination students, please do remember the article. Absolute beautiful articles are there which can be directly asked in the examination. Okay. But you have to, one more important point is there. The salaries of the judges and High Court and Supreme Court judges could be decreased, okay, during financial emergency, okay, which is discussed under Article 360. Okay, so yeah, but that is not the statement. Fine. Judges of Supreme Court cannot plead in any court. After retirement, judges of Supreme Court shall not plead or act in any court or before any authority within the territory of India. The question may come, a retired Supreme Court or High Court judge, Supreme Court or High Court judge could, okay, could be a could be appointed as a chief justice or attorney in IMF, in W Bank, means yes. Okay, we are not discussing High Court now. Let us see the Supreme Court. A retired Supreme Court judge, can be reappointed, can be appointed as an attorney or a chief justice of IMF, World Bank, or UNCAD. Okay, an International Court of Justice. Lot of arbitration international institutions are there. Can he be appointed? Means yes. Why? Because the Constitution asks him that you cannot plead within the territory of India, but he can plead outside the territory of India. So how beautiful they can twist here the question. Okay, that's why we are having 1 2 4 5 is the right answer. This is a wrong one. Okay, chalo, bigger one it was. Consider the following statements. Supreme Court of India can make rules to regulate its own procedure consulting president. Okay, means Supreme Court of India, suppose Supreme Court of India is there. Supreme Court may say that criminal cases should be filed in this way. civil cases should be filed in this way. This is a way of appeal. You should get a certificate of appeal from the lower courts if you want to apply if you want to appeal in the Supreme Court. Okay, and these are the rules. An advocate should have this much of qualification. Okay, and etc. So and so he should be a member of bar council. So like that, any rules, any regulations. Supreme Court can make its own rules, can regulate its rules, can remove rules, can add rules, can modify rules, whatever they can do with regard to their procedure of working, but they have to consult the president. This is here, twist is there. Okay, but this is the absolutely wrong answer. Why? Because they don't need to consult the president. Second one, the rule made by SC are subjected to parliamentary ratification. Absolutely wrong. Okay, parliamentary or president should not be involved with regard to SC Supreme Court function. The rule, being in nature of subordinate legislation, cannot override the constitutional provisions. Very, very, very right. So answer is only 3. With regard to Supreme Court, whatever the constitutional provisions are there, 123, 124, 125, whatever the constitutional provisions are there, okay, if the rules and regulations abridges or try to alter or twist or modify any of these provisions, that will not be acceptable. Remember this point. So they can make rules and regulations. They can regulate their procedure. They can regulate their trials. They can regulate their working mechanism. They can make new rules. They can add new rules. They can remove rules. But they should not override any of the constitutional provisions which are mentioned in their articles. Only 3 is right. Okay. Our Supreme Court is vested by the Constitution itself with the power to deliver advisory opinion on any question. Okay. So this is not important now. Actually, I have to read this one. The power of Supreme Court to make rules to regulate its own procedure is subjected to only 2 limitations. Remember this point. Means they can make any rules according to their whatever the convenience or governance. According to that, they can make their own rules, but only 2 limitations are there. First is, these rules are subject to the laws made by the parliament. Okay, here I have given ratification. Ratification means nothing but certification. Certification is nothing but, suppose you have done a course from me. You have done a course of like a painting course from me. So you have showed me the painting. You have taken the test. I have certified Mr. So and so is level 1 painter. Okay. This is your certification. This is used. This is what generally recognized by many people. Fine. In the same way, ratification is nothing but Supreme Court makes rules and regulations. Okay. After making the rules and regulation, point number 1, 2, 3, 4, 5, it should go to the parliament. Parliament should read out these rules, and parliament should also pass. Means Lok Sabha should pass, Rajya Sabha. This is called as ratification. But this is not the process. This is the all wrong process. Fine. So ratification by parliament is not there with regard to any rules and regulations made by Supreme Court. But whenever any law is made, like Environment Protection Act is there, fine. National Highway Authority Act is there. Insurance Regulatory Development Authority Act is there. Air Pollution Prevention Control Act is there. Water Pollution Prevention Control Act is there. FRBM Act is there. Okay, CPC is there, CRPC is there, many are there like that. IPC is there, criminal. So these are all made by whom? These are all made by, like, not only these acts. Okay, Triple Talaq Ban Act is also there. Hindu Succession Act is also there. Dowry Prohibition Act is also there. Sati Abolition and Prevention Act is also there. Child Marriage Restraint Act is also there, right? Many acts are made. Many acts are made by the parliament. So whenever Supreme Court makes any rules and regulation, they should not violate these laws made by the parliament. That's all. Okay. Their rules and regulations should not violate any of the laws made by the parliament. That's all they have to see. Second one is absolutely right. The rules and regulations made by the Supreme Court should not override, should not replace. Override means nothing but replace. should not replace constitutional provisions mentioned in the constitution. Only two limitations are there, rest they are free. They can make any rules of their choice. Okay, so that is why I have to tell you, I have already told you that they can make rules and regulations consulting president. No, they can make rules and regulations. Only two limitations are there. Talk of there is no talk of president here, right or wrong? Where is president here? Not. Where is president here? No. So there is nothing about president, so that is wrong. The rules made by the Supreme Court are subjected to parliamentary ratification. Wrong. But the rules made by Supreme Court are subjected to limitations made by parliamentary laws. Right. This is right. The rules and regulations have to be inconsistent. Means it should be consistent with the parliamentary laws. I should not violate that laws. Okay, I think you got it. And it is very common. Any rule or any regulations, if they made, they should not replace the original constitutional provisions. Okay. That's why 1 and 2 are wrong, only 3 is right. Okay. Absolutely wonderful. Consider the following statement. A Supreme Court is imperative. Imperative means compulsory when the country's distribution of power is derived from federalism. This is right. In unitary constitution like in England, as lower courts just act as mere subordinate bodies, it does not require determining disputes of federal character. Federal character. Remember this point. So what it is saying, this is both 1 and 2 are right. Why do we want a Supreme Court? Okay. Why do we want a Supreme Court? Why? Because in a country where there is a clear demarcation of power is there between union and state. Union listed there, state listed there. When there is a clear demarcation of jurisdiction is given to union government and to the state government by the constitution itself. So there should be some body, right? There should be some authority which should be solving the disputes between them or not. Yes, because it may happen union government may encroach the jurisdiction of state government, and state government may exceed its jurisdiction and encroach some of the items, some of the subjects of the union government, right? In this case, there should be some authority, right? Yes. So Supreme Court is important here. Supreme Court is important. And England, there is no such division of powers. England, there is no such division of powers. When some division of powers is not there, so why do they need a court which should solve the disputes of units? Okay, because they don't have the system of federalism itself. Okay, only all subjects are done by UK Parliament. All subjects are done by UK Parliament. So UK Parliament and court, they will be always having a problem. They will have their own cases. Means UK Parliament and UK Court, UK Supreme Court, UK Parliament, UK Supreme Court. If any laws are against the population, in UK, if the laws are against the population, the people can file a case in the UK Supreme Court. Okay, so then the Supreme Court will see that whether it is right or wrong. Whether it is right or wrong, then the Supreme Court will see. Okay, whereas that's why Supreme Court is supreme in UK. In Britain, Supreme Court is supreme. Any laws made by the Parliament, it can directly struck down. It can directly struck down against the constitution. They don't have anyhow constitution, against the freedom of the people, against any of the morality or social wrong. If anything is happening, if any law is made with regard to any of these evils, okay, with regard to restraint of personal liberty, personal freedom, right to properties, if any of this restrained by Parliament, UK Parliament Act, Supreme Court will jump into it and try to make it white. Okay, because they are not having UK Parliament, UK, United Kingdom, the Britain does not have units, and where there are separation of powers. So in a unitary government, in a unitary country, you don't require a court which solve the federal disputes. Okay, remember this point. But federal disputes solving authority is very, very important, very, very imperative, compulsory, where the power of the units is derived from federalism. Derived from federalism. I hope you got it. If not that, I am having a Telegram group. You can ask me that again. I'll put a audio. Okay, I think this is more than enough. Both are right. So this is the explanation, whatever is there, exact explanation is there. Please do remember the explanation. Whatever I have told you, the same explanation is there. A concept explanation is there, theoretical. Please go through it. Now consider the following statement. Article 13 declares it is a positive affirmation. Article 13, this declare you just rub it. Article 13 is a positive affirmation to the citizen of India against arbitrary law of legislature or not? Yes. If the legislature makes any law which is unconstitutional, which is against the larger public interest, the people of India can file a case in Supreme Court. Okay. So under Article 13, we will get the justice. Okay, we'll get the justice. So unconstitutional laws will be struck down. Larger public interest laws will be passed. Law will be passed, and if it is against the larger public interest, it will be declared as void or invalid Remember this point. So it is very good. Article 13 is positive, means it allows the Supreme Court that you please see that any laws made by the state or the union government is inconsistent with constitution or not. It's a positive push given by the constitution to the Supreme Court under Article 13. There is no clear provision to declare a state law void when it is inconsistent with the state and union government laws. Okay, but this is a wrong. There is a clear provision is there. I guess Article 240 plus some article is there that I don't remember, but remember this point. There is a clear cut provision article is there which says that if a state law is passed and it is inconsistent with union law, means it is not in compliance with union law, then Supreme Court can declare the state law as void. This is a clear-cut provision is there. I don't remember, but I remember the concept here. Remember this point. If any inconsistency is there between state government and the central government laws, then Supreme Court can declare the state government laws as void, invalid. Okay. So that's why there is no clear provision is there. No, this is wrong. There is a clear provision is there. That's why this is wrong. This is right. Only one. So we are having here what? Sorry. Correct the incorrect statement. Choose the incorrect statement, right? So incorrect is only 2. Only 2 is incorrect. 1 is absolutely fine. The Supreme Court of India has no original jurisdiction in the following matters. The first one is very right. Any disputes arising out of treaty, agreement, covenant, engagement, sanad before the commencement of constitution, or any of the similar arrangements between the state and union government entered before commencement of the constitution. Right. So any agreement between Telangana and Andhra Pradesh, any agreement between Telangana and Maharashtra, any agreement of sharing of water between Telangana and Karnataka, like that, if any of these units have made agreements before the commencement of the constitution, then Supreme Court will not have original jurisdiction. For that purpose, a separate body will be created to solve it. Remember this point. President can refer these disputes to Supreme Court. Okay, whose recommendations or judgments will become obligatory. Suppose there is a Telangana is there, Maharashtra is there. As far as I know, we are having a project called as Lindy project, irrigation project. It's an irrigation project. So Maharashtra and Telangana has made an arrangement that we'll share this much, we'll share that much. Suppose rainfall is less, and now Maharashtra is demanding more water. And Telangana government is saying, according to our agreement, you should be given 40%. But you are asking now 60%. Maharashtra is saying, we are having lot of drought, we want 60%. So it is against the agreement made by the two states or not?
And you know that Supreme Court is one which solve the disputes of federal nature, between states and state, between two state and state, between union and state, between state and union territory, anything, any combination of state and union territory and union government you take, Supreme Court is one which solves it. Supreme Court is one which solves it. Now, if this is a dispute, so for that purpose, you know that we are having in constitution interstate river water board will be created. Okay, because you know that these provisions again cannot be heard by Supreme Court, cannot be heard by, because they don't enjoy original jurisdictions here. Okay, first they have to be heard by there, again they can make an appeal there, that is another matter, but not original. That's why I am saying what original jurisdiction is not there. Directly Telangana cannot file a case in Supreme Court. Okay, first of all, a board will be created. That board will decide. They will give the judgment. If you don't like it, then you go to what? Supreme Court. But Supreme Court does not enjoy the original jurisdiction with regard to these disputes. Okay, with regard to these disputes. But President may say, "Arey bhai, ye do lad le rahe." President may say, "These two people are fighting a lot of protest is going on here and there. Supreme Court, can you do something on it?" Supreme Court will say, "Yes, sir, we'll do." Supreme Court has done the total research on it, and Supreme Court has given a judgment that no, the agreement has to be followed. Maharashtra cannot be given more than 40% because the state of Telangana is also in semi-arid, and they are also having successive droughts are there in their state also. So we cannot violate this agreement. Supreme Court told to President. Whether this recommendation becomes obligatory to be followed by the state? No, no, no. These recommendations of the Supreme Court to the President are in advisory in nature. So Supreme Court does not enjoy original jurisdiction with regard to river disputes. First of all, it has to go to a board, then you can make appeal. But appellate jurisdiction is there, but original is not there. Very, very important points I am discussing. I hope that you are getting a lot. चलो देख लेंगे. One class of disputes, though they are federal in nature, because Telangana and Maharashtra both are the unit, state unit. They are having a disputes of irrigation project. That it means both states are involved, means federal dispute. Though they are in federal dispute, federal in nature, they are excluded from original jurisdiction of Supreme Court. Okay. What kind of any treaty, any agreement, any engagement, any other instrument which has entered into or executed before the commencement of these constitutions. Okay. Before the commencement of the constitution, it is not under Supreme Court. It is not under original jurisdiction of Supreme Court. Again, but these disputes may be referred by the President to the Supreme Court. Yes, but for advisory opinion. That does not obligatory becomes on the President. Remember this point. And you should know this about many disputes happen between states and states. But what happened at the end? What happened? Many disputes which are not in federal, which does not become a part of original jurisdiction of Supreme Court. Many disputes which are not a part of original jurisdiction of Supreme Court, but are in federal in nature. Many disputes have arose after the independence between many states. But what they have done is the states, they themselves have solved the problems by adjudication. No, not adjudication. They have we got a term here, by negotiation. Okay, the states and state have sat together and they have made a negotiation, an agreement. With that they only solved all the disputes. Okay, which are not under the original jurisdiction of Supreme Court, but still of federal nature. They only solved it. Okay, and never done by court. When a court solved a case, then it is called as adjudication. Remember this point. So many disputes of federal nature was there, but does not be a part of original jurisdiction of Supreme Court, but was solved by the states themselves. Their CMs and all, they met and they solved it. But they have not taken what? Adjudication route. They have not taken. The first suit brought by the state of West Bengal against the Union of India in 1961. Okay, so the first suit in 1961, for the very first time a suit was filed in the Supreme Court. Supreme Court against Union of India, against Government of India. This is the first one. Before that, they only solved by agreement and all. Okay, so that's why I told here, President can refer this dispute to Supreme Court, yes, but the recommendations are not obligatory, they are advisory. These two are anyhow right. So choose the correct statements 1 and 2. 1 and 2. Please remember this point. Consider the following statements regarding original jurisdiction of Supreme Court. So these two are anyhow asked in my previous exam level 11 to 15th question. There was one question was there, so both are right. So I am not going to explain this. It is already discussed in detail in my last video. 18th one, the jurisdiction of Supreme Court on matter related to Article 32. Very important. As you know that exclusive means no other court can hear the plea at first instance than Supreme Court. No other court can hear the plea at first instance than the Supreme Court. It means what Supreme Court should first hear that case. That is called as exclusivity. And that is called as original. Means it belongs to Supreme Court and only Supreme Court should hear. Means this particular matter should be decided by Supreme Court. That is called as original. This particular matter should be decided by Supreme Court original. Okay. Exclusive means the matter is anyhow with the Supreme Court original jurisdiction. Exclusive means no other court should hear it. So this is very important. So here the correct option is A. Only one. Remember this point. See, because Article 32 deals with writs, you all know that. Habeas corpus, mandamus, quo warranto, certiorari, we are having all of this. Okay. If any person like habeas corpus, if Mr. On has been arrested by Telangana police Telangana police, and Mr. On is saying that I have done nothing, why are you arresting me? Then it is a short case of habeas corpus. Okay, according to this article, Mr. On will be taken to a magistrate. Okay, and magistrate will ask, why Mr. Police you have arrested Mr. On? Then Mr. Police should say that so and so crime he has done, etc. And Mr. On will say, I have not done. In this way, a small trial, you can say, a small trial will happen there. If the magistrate or judge thinks that the arrest of Mr. On is wrong, he will be set free. That's why Article 32 is called as what? Bulwark of freedom also. Bulwark of individual freedom. It means it will free the person from the tyranny of state, from the arbitrary or abusive use of state power. It will free an individual. Okay, Mr. On will now go happily to his home. Because there are no grounds established by police why they have arrested. Right? So, Article 32 is fundamental right. And fundamental right, anything regard to fundamental rights, it's the original jurisdiction of Supreme Court. But now question is whether it is exclusive or not. It is not exclusive. Okay, even High Court can directly hear that cases. At the first instance, the aggrieved person, Mr. On, can also file in High Court. Okay, so with regard to writs could be issued by both Supreme Court and High Court. So it means it is not exclusive to the Supreme Court, because even High Court are hearing the writs related to constitutional remedies. Understood my point? I guess you got it. Okay, that's why it is only the original but not exclusive. Why? Because High Court is a part of it. The answer here will be only one. So this is how the questions will be twisted. Okay. Because see, though the aggrieved party has right to directly move to the Supreme Court if Mr. On fundamental right has been violated by the state government or it's any of the statutory authority, he can directly go to the Supreme Court. Instead of going, he can also go through a High Court. That's why it is not exclusive only to the Supreme Court. Only to the Supreme Court. Please remember this point. So, and Article 131 is the powers of High Court where they exercised writ jurisdiction. Writ jurisdiction of High Court is the Article 131. So, Article 32 of Supreme Court. Okay, Supreme Court will look after it. Article 30 both deals with what? Writ jurisdiction. Please remember this point. It is treated as, because anything with regard to fundamental rights, it is the Supreme Court is a tiger for it. That's why it is Article 32 is the original jurisdiction of Supreme Court, because any law against fundamental rights have to be decided by what? Supreme Court. Originally it belongs to them, but not exclusive, to Supreme Court. The 19th one, the appellate jurisdiction of Supreme Court is concerned with cases involving interpretation of law, civil and criminal cases involving interpretation of Constitution. Certificate of High Court is essential for a litigant to appeal in Supreme Court. Certificate of High Court is essential. Let us see. Interpretation of Constitution means Article 32 dealing with habeas corpus. Okay. And the High Court has missed and has wrongly interpreted the Constitution and agreed the arrest of Mr. On. Agreed the arrest of Mr. On. So the lawyer plays a very important role here. Lawyer like me, they will play a very important role. They will go and appeal in the Supreme Court saying that Article 32 is wrongly interpreted. Last time when you have given a judgment, sir, this judgment is the Supreme Court judgments are binding on all courts or not? Yes. Sir, in 1960 you have given a judgment on the same case. That judgment says that this particular person on this ground should be freed. But the High Court has not seen your precedent. We call them as precedents. Already established rules are called as precedent. High Court have not seen your Supreme Court, the 1960 judgment, and on the same ground he was arrested. But you have left the person free at that time. Then a matter of constitutional interpretation has got what? Dissolved. Okay, there is now conflict between the interpretation of the Constitution. Why it happened? Then that case will be taken by the Supreme Court. Okay, interpretation of Constitution is there. No, I will come to the picture like that. Civil cases, criminal cases involving interpretation of Constitution. Okay, it does not require interpretation of Constitution, irrespective whether any civil case, any criminal case, you can directly go to the but lower court, from session court, civil court, then you go to High Court, then you go to Supreme Court, but you can appeal to the highest court of land. You don't need to, it does not necessarily mean that a interpretation of Constitution should be there. Okay. And certificate of High Court is essential for litigant to appeal in Supreme Court. Let us see this. The Supreme Court is the highest court of appeal for all courts. Remember this point, in the territory of India. It here appeals from India having, okay, this is not important. Okay, this is important. The appellate jurisdiction of Supreme Court may be divided into three heads. Cases involving interpretation of Constitution. If any civil cases, if any criminal cases are having any 395 articles has been wrongly interpreted by High Courts, then it can go to the Supreme Court. Okay, then lawyer has to show, advocate has to show that in this my land dispute, this particular right to property which is given under Article 300A has been not properly interpreted by the High Court, and he has given a judgment against me. Then the lawyer will say that my client should be heard in Supreme Court, because here the question of interpretation of Constitution has come into picture. So they have to establish, the lawyer should have this art to establish that there is a constitutional provisions breach is there. Then only it is possible, otherwise not possible. Even in criminal cases the same. Civil cases irrespective of any constitutional provision. Criminal cases irrespective of any constitutional question. Okay, that is what I have told you. Civil cases and criminal cases involving interpretation of constitution not required. We have already discussed here. Okay, we have already discussed that civil cases irrespective of constitutional question, criminal cases irrespective. Here what is written? Involving means this is wrong. This is wrong. Okay, and this is anyhow right. Anyhow right. Third one we have to see. Yeah. High Court, if the High Court has refused to grant a certificate of appeal, but Supreme Court satisfied by the lawyers, okay, petition that there is again an interpretation of constitution is there which has been overlooked by the High Court judge, which has been overlooked by the lower court judge, then Supreme Court can directly take it. Supreme Court can directly take it. So having a certificate of High Court for appeal is not required. Appeal is not required. So, but what he has written, what I have given you, certificate of High Court is essential, not essential, not essential. Okay. If Supreme Court satisfies that there is a constitutional interpretation conflict is there with regard to the judgment, okay, then judgment of High Court, then Supreme Court will take it. So we are having here, find the correct statement. So here it is not there. Incorrect statement I have to. I did not put incorrect here. It should be incorrect. 2 and 3 are incorrect. 2 and 3 are incorrect. Please remember this point. The last one is very, very easy. The Supreme Court judge who was appointed as CGI superseding other senior most judges. As you know that Chief Justice of India, the procedure to elect Chief Justice of India is nothing but the senior most judge of Supreme Court will become what? Chief Justice of India. This is the customary procedure to appoint a Chief Justice of India. But there are two instances happen where senior most judge of Supreme Court, senior most judges of Supreme Court were overlooked, and a judge of less than their age and seniority has been promoted as Chief Justice of India. Has been promoted as Chief Justice of India, superseding is nothing but, even though seniority wise there are some judges are there, but they are overlooked, they were not appointed as a Chief Justice of India, someone else of their less seniority was appointed, right? There are no safeguards in case of appointment of Chief Justice of India, because appudu ek wo zamane mein when A.N. Roy was appointed Chief Justice, he has superseded 3 senior judges, H. Grover and Shelwath. Then there was an uproar in Supreme Court. Bar Association joined also. Okay. And the Supreme Court judges has been superseded solely because their judgment in Keshav Nanda case. Keshav Nanda case, okay, which actually curtailed parliamentary powers, right or wrong? Basic structure doctrine was introduced by Supreme Court in Keshav Nanda case, and this basic structure doctrine of basic structure was very much okay, created anger among the parliamentarians at that time, because the basic structure of the doctrine of basic structure has put n number of curtailments, limitations, constraints with regard to parliament laws, and these 3, H. Grover, Shelwath, they were the 13 bench judge. Okay, Keshav Nanda Bharti case, how many judges gave the judgment? 13 judges gave the judgment. Okay, everywhere. Do you remember? Do you know this? 13 bench means what? 13 bench is nothing but in one bench all the 13 members are sitting. It's not like that. 13 courts will be there. 13 courts will be there, and all of them are reviewing the same petition. All of them are reviewing the same petition. In that, 7 members was in the favor of doctrine of basic structure, 6 members were not in the favor. Just by one judge, the KBC, Keshav Nanda Bharti case has won, and doctrine of basic structure has been introduced in our country. The same thing happened even in Ram Mandir and Babri Masjid case also. Okay, 3 judges, 3 bench, Supreme Court bench was created, 3 judge bench was created. One gave some other a kind of its own methodology how to divide the land. and second judge, third judge. So there was no conclusive, okay, about all of them. They have given different judgments. Okay. So I think you got it. So KBC, Keshavananda Bharti case has literally made the parliament furious, and these three judges were a part of this judgment also. That's why the government at the time got anger on them, and what they have done is they have not appointed them as the Chief Justice of India. A younger judge has been, younger in seniority, has been appointed as the Chief Justice of India. Just because at that time, government government political interference was there. Political interference was there. Again in 1977, instead of H.R. Khanna, who was a senior most judge, M.U. Beg was appointed. M.U. Beg was appointed. Okay, why? Because there was a case with regard to ADM versus Shukla case. Okay, in that case was not in the favor of government. That case was not in the favor of government, and government again got hurt. And separation of DES, this judge, H.R. Khanna, has given a descending judgment. Descending means which is not in the favor of government. That's why, to take revenge from this person also, Supreme Court, the government did not appoint him. Then a proper methodology was devised. Now Supreme Chief Justice of India will be appointed, like second judge case, third judge case, you might have heard in the polity also. So in the third judge case, it was now an established principle, whatever may be, the senior most judge will be the Chief Justice of India. So our answer two times, A.N. Roy and M.U. Beg. A.N. Roy and story I have told you, A.N. Roy and M.U. Beg. So answer is 3 and 4. 3 and 4 is the answer. I'll not take much of your time. So thanks a lot. Please spread my YouTube channel and join my Telegram. My Telegram group is Bright Minds IAS. So a hyphen is there and Shujathullah is there. My students, anyhow, they will promote. And thank you. Bye bye. Have a nice day.